They are new every morning, new every morning. Great is thy faithfulness, O Lord. Great is thy faithfulness. The steadfast love of the Lord never ceases. His mercies never come to an end. They are new every morning, new every morning. Great is thy faithfulness, O Lord. Great is thy faithfulness. They are new every morning, new every morning. Great is thy faithfulness, O Lord. Great is thy faithfulness.
Good evening, everyone. We are indeed happy to be here again. We had some glitches a while ago with our internet connection, and I apologize for those who probably were not hearing anything or seeing anything. But we are back on, and hopefully everything will go well for the rest of the evening. So we give God thanks once again that He has allowed us to come together as we seek to share as His people together in all that He calls us to do. So welcome to everyone, both on Zoom and on YouTube. And this evening we are going to be taking a break, and that we are going into our wrap session, as we would have indicated that during the months of May and June, we tend to look at some family issues. And so this evening we are going to be sharing in one of those. But before we get there, let us listen to a word of song, and you can sing along if you know this. We will stand.
Sometimes it's hard for me to understand why we pull away from each other so easily, even though we're all walking the same road. Yet we build dividing walls between our brothers and our selves. But I don't care what label you may wear. If you believe in Jesus, you belong with me. The bond we share is all I care to see, and we'll change the world forever. You will join with me. Join and sing, sing. You're my brother, you're my sister. So take me by the hand. Together we will work until He comes. And there's no foe that can defeat us. We're walking side by side. As long as there is love, we will stand. The day will come, we will be as one, and with a mighty voice, together we will proclaim that Jesus Jesus is King. It will echo through the earth. It will shake the nations, and the world will see that you're my as long as there is love, we will stand. Take me by the hand, join with me, join and sing. You're my brother, you're my sister, so take me by the hand. Together we will work till it comes. There is no foe that can defeat us. We all will walk side by side as long as there is love. As long as there is love, we will stand. You're my brother, you're my sister, you're my sister. So take me by the hand, take my hand. Together we will work till it comes. There's no foe that can defeat us. We all walking side by side as long as there is love. We're gonna stand, You're my brother, you're my sister. I love you. Take me by the hand, in your hand stand.
I apologize. My mic was muted. All right. So 1 John chapter 4, verse 7 through to 12. Dear friends, let us love one another, for love comes from God. Everyone who loves has been born of God and knows God. Whoever does not love does not know God, because God is love. This is how God shows his love among us. He sent his one and only Son into the world that we might live through him. This is love. Not that we love God, but that he loved us and sent his Son as an atoning sacrifice for our sins. Dear friends, since God so loved us, we also ought to love one another. No one has ever seen God, but if we love one another, God lives in us and his love is made complete in us. The word of the Lord. Brothers and sisters, we have been having some glitches this evening. I hope nonetheless they will not prevent us from having our time together as we normally do each week. So let me, for those who may have joined after I extended the welcome, let me say welcome again to everyone on Zoom and on YouTube. And we are happy to have you once more with us this evening. As I indicated at the start, May and June, those 2 months are normally when many churches observe, and we do too, Family Month. And so we use the time to see if we can maybe look at some issues related to the family and take the time out to address these, whether they be social issues, personal family issues, anything that we think that we can do to help to make for more harmonious families. And we have discovered that one of the issues that seems to be a hot issue among family members, cause a lot of disturbance and problems, breakup in families. We have heard of domestic disputes, has to do with what happened when a family member dies, especially a parent. But when there's a death of a family member, and how do we deal with what is left behind, the legacy, the things that, the possessions and the things that must be divided and distributed or become someone else's possession. And what we have seen over the years in our country, and I don't know if this may be happening elsewhere for those who are joining us from other countries, it sometimes break up families because things are not dealt with properly. And we recognize that probably if certain things are put in place prior to this, some of those problems that we see happening would not take place. And we all have heard about them. We may have spoken to individuals and so on. This evening, we have an attorney at law who is going to share with us on what to do, as we say in Jamaica, with dead left, right? And he will be taking us through a presentation as to what legally we should do to deal with things that we have now while we are alive, to prevent any problems from coming on later on. And if no will or no provisions were made, the procedure. So we have with us this evening no stranger, in fact, one of our own, Mr. Kemar Sutherland, attorney at law. And so he's going to be taking us through the presentation this evening. As we said, Mr. Sutherland is a member of the Emmanuel Baptist Church. And therefore, I think maybe all of us, or for most of us, we would know him. So he's no stranger. And so at this time, Mr. Sutherland, we turn over to you, sir, and ask you to take it away. We're going to ask persons to hold your questions until the end of the presentation. Come on, you may go ahead.
Thank you, Rev. Are you hearing me, Rev?
Yes, yes, we are.
Okay, perfect. Right, good evening, everybody. As Rev said, most of you would have already known me or would have already interacted with me at some point. For those who don't know me, I am Kemar Sutherland. I grew up in the Emmanuel Baptist Church, and I am now an attorney at law. Rev has asked me to make this presentation because, as he said, we realize that more often than not, people die or pass away, for that matter, leaving assets, land, houses, cars, money, whatever it is that they own, but no proper provisions are made for what is to happen to those things after the person dies. And so today's presentation will be on what we call deadlift. Are you seeing the screen, Rev?
Yes, yes, yes.
Okay. So as we would have said, whatever you own during your lifetime can be passed on to your children or to another family member, to the church, to whoever it is you want after death. But there are procedures in place by law that allows for the smooth division or the smooth administration of your estate after you die. However, in order to take advantage of those processes, you must first either make a will or a trust or give directions as to what is to happen when you die. So I've decided to split this presentation basically into two parts. The first part will deal with what happens to land that you think you have inherited. So, for example, one good example is family land. So your grandmother used to live on a piece of land, and then she died, and your mother just lived there still because she grew up there. And then your mother died, or your mother is still alive, and you come and live with her. She gets old. She's at that point where she may go, and you think that land is now going to belong to you because it's been in your family since Gilbert. So we'll deal with things you think you've inherited, and if you don't own them, if it wasn't distributed to you through the proper channels, what options are available to you to put yourself in a position to own that piece of land, that car, the money, etc. The second aspect of the presentation will be centered around things you already own and intend to pass on to either your children or some other person in your life. So that will focus on preparing your will, how to prepare your will, what is a will, and the different elements that go into creating a valid will. All right, so the slide that's on the screen now is trying to define what is deadlift, and that's any asset or item that you own that is capable of being gifted. Basically, any tangible item, anything you own, whether it be land, your car, money in your bank account, your jewelry, furniture in your house. If you have a laptop and you feel like when you die, that laptop must go to Rev, you can put that in your will as well. Any physical thing that you own, you can give it away to somebody else. There are some exceptions, but we will get into that further in the presentation. So we're focusing mainly on land today. And as I said, family land is a good example of something that people think that because, you know, their grandfather used to own it and then the mother or the father and know them, that they are now the owners of that land. Yeah, so how it is that land is passed along through generations is that first, someone in your family has to own that land, or somebody you know has to own the land. And by owning the land, it means that if the land has a title, your name is registered on that title as the owner. And all titles for any land that is registered is kept at the titles office in Kingston. If your name is not on that title, it means you don't own the land, basically. If the land is unregistered, meaning there is no title for the land, then the way to know who owns it is through what we call a deed of conveyance. So it's basically, a deed of conveyance is basically a document that says, I bought this piece of land from Rev, and it has the details of the transaction. It's basically like a receipt. So if you can't find one of those to say your grandmother did buy the land or your great grandfather bought the land, then you won't know who really owns the land. And as such, you also can't say you own the land. But let's say you find out that your great grandfather owned the land, his name is on the title, or he bought the land and his name is on the deed. Then the next step is what we call probate proceedings. If it is that the person who owned the land died and they left a will, then you can probate the will, meaning you can go to the court, show them the will, and they will decide if the will is valid or if the will is real. And based on the contents of the will, they'll distribute the land in that manner. So let's say, for example, Rev owns a piece of land in Port Maria, Baptist Church land. If Rev makes a will and says that when I die, I want this piece of land to go to Sister Gwendolyn Robinson, he'll write that in his will. And when he dies, his executors or the people he named in the will take that to the court, and they will say, okay, you can go ahead and honor the wishes of Rev. And you go to the National Land Agency and say, hey, look, I have this will that says the land will go to Sister Gwendolyn Robinson. Please put Sister Gwendolyn Robinson's name on the title, and the land agency will do that at a cost. And then Sister Robbie will now be the new owner. If it is that that process doesn't happen at all, then Sister Robbie can't say she owned the land at all. Even if she has lived there from she was 2 years old, she cannot say she owns the land unless it was passed down to her through that process. So, as I said before, you know, there are two ways to find out who owns the land. In Jamaica, we have basically two classifications of land. There's registered land, there's unregistered land. Registered land simply means that somebody went to the titles office, gave them a drawing of the land, and they made a title to match that land. So they have a record that that land exists. Unregistered land is just land that's there that nobody has registered as yet. It doesn't mean nobody owns it, or it doesn't mean that it's just wasteland. It just means there's no title corresponding with that particular plot of land. So for the registered land, you can go to the land agency, titles office, and ask them for a copy of the title, and that will tell you who owns that particular plot of land. For the unregistered land, you will have to either go through your parents' old stuff, your grandmother leave some paper around the house, go through them and find out if there's a receipt, if there's any proof that you purchased the land, anything like that. If you can't find any of those documents, you can go to the tax office and give them the address for the property, and they will likely have it recorded and tell you the person who has either been paying the taxes or the person who first registered to pay the taxes, which is usually the person who owns the land. So that's the first step in finding out whether you can either get the land or who the land belongs to, or whether the land you're living on is yours, or whether you're entitled to it. Still hearing me, Rep?
Yes, yes. Sorry, I had you muted. Yes, we're still hearing you.
Okay, perfect. So I hope I haven't lost anybody as yet. So just before we go any further, I'll just give a quick recap. So what we refer to as dead left is basically anything that a person has left behind after their death. Any physical thing, money in a bank account, anything like that. As it relates to land specifically, if a person was living on a plot of land and they die, it doesn't necessarily mean that you now own that land because you were living there with them for 50 years. If that person wasn't the true owner of the land, they cannot pass it on to you. And even if they were the true owner of the land, there's a process that they have to go through to pass it on to you. And if that process was not done, then you yourself cannot state that you own the land. Even though you live there, even though nobody is troubling you, even though all your neighbors know that, listen, this is Linda Sutherland land, she lived there from she's a little girl, it doesn't necessarily mean that you own the land, which is why sometimes you'll see people on the news saying that they lived there with their grandmother for 50 years and now the government coming to take them off, or now somebody else coming to take them off. It's because they really didn't own the land and they didn't take steps to own the land. So let's say you find you live on land now and you want to take steps to put yourself in a position to own that land because, you know, it wasn't done before. You didn't know that you had to do something. The first thing you can do are probate proceedings. So I had mentioned this before. If the person died and they left a will, a valid will, then you can probate that will. If the person died, they own the land, but they died and they didn't leave a will, then what you would do is you'd go to the court and ask them to be able to administer the estate through the process we call administration. Now, since the person didn't leave a will stating who should get the property or, you know, how it should be dealt with, whether they should sell it, they didn't leave any instructions at all, administration would be governed by the law. There's a law which covers basically dead left when nobody gives instructions, and it would tell that, you know, a person dies, if they're married, half of what they own go to the wife or the husband. If they have children, the other half go to the children. There's no wife or children, then it goes to your parents. No parents, brothers and sisters, no brothers and sisters, uncles and aunts, and it goes on. And if you have nobody at all, then your dead left assets or your dead left land goes to the government. If you can't find out who owns the land, you can't find the title, or you can't find the deed, or you do find these things and realize that you thought your father owned it, but really is a man named Jeff who died in 1980, then what you can do is say, okay, I've been living here for 20 years. The owner dead. There's nobody who has come to trouble me. Everybody in the community knows that you know, I'm the one that lives here, you can go to the titles office and tell them that, listen, I've been paying the taxes, I've been taking care of the land for the last 12 years, and I think that I should be the rightful owner. And the titles office will look at your application, they will do their own research, and if they believe what you say, then they will register you as the owner for the property. In order to take advantage of the adverse possession laws, one, you would have had to live on the property undisturbed, meaning nobody never come run you off, or you never go to court because you're on the land. You would have had to be there for at least 12 years. If the land is owned by the government, however, then you would have had to be living there, or you would have had to be living there with a parent or a grandparent for at least 60 years. So for government land, 60 years. For land that's owned by just a regular person, you just have to prove that you were there for 12 years. You could always also, if you find out that somebody owned the land and they just didn't know that you were living there, you can approach that person and offer to buy the land. But that is often not the case. Most persons just end up going with options 1, 2, or 3. For all these options, I must say there is a cost, whether it be the costs for paying your lawyer. Different lawyers charge different rates, but you have to first pay the taxes on the property itself. You will also have to pay what we call death duties or death taxes. So you'll go to the tax office and tell them that you're trying to get this piece of land. They will find out the value of the property, and then they will charge you 6%. They will charge you a percentage. Last time I checked, I believe it was 6%. But they will charge you a percentage of the value of the property in taxes. And if you don't pay that within the first year, after the person dies, then it attracts interest. And that interest will continue to grow until you pay for it. That happens with both probate and administration proceedings. If you're going the adverse possession route, then all you have to do is pay the taxes on the property, which everybody pays property taxes each year. And then you just pay the fees for getting a new title and advertising your application in either the Gleaner or the Observer, which you'll be directed to do at the end of the proceedings when the application is approved. All right, so that is basically how you deal with deadlift. You really have to find out who really owned the land and then see what avenue you have to getting your name on the title or to putting yourself in a position to own it. There are times when there's nothing you can do, either because the person willed the land to somebody else, or because if there was no will, the law says that it goes to the wife and you are way down on the list of priority people to get the land. There's just sometimes that you just can't acquire the land. No matter how hard you try, you end up having to either buy it or just live there and hope nobody kicks you off. But for the most part, one of those 3 options should be available to you at some point. Now, to items that you actually own, that you're sure that you own, and that you intend to leave for somebody else after you die. The best option always is to have a will. So a lot of people know, especially older people, know that you can just go to the bookstore and buy a form, a time store will, and fill it out yourself. And that is that is fine. If you only have one piece of land or you only have one car that you intend to leave, by all means, you can do that and have little to no problem whenever it's time for that will to be probated. However, if it's more complex for you, you have more assets, 6 different bank accounts, land here, a house there, 2 cars, you have multiple things. It's a bit more difficult for you to use a time store will. And in that case, I would advise that you speak to a lawyer. Even if you're going to write the will yourself, at least speak to a lawyer first to know what exactly you have to say when you write it and the form that you have to write it in, because every will, or under the law, there's a Wills Act, and in that act, it stipulates exactly how your will is supposed to be prepared. It has formalities that if they aren't honored, then your will won't be valid, and it would be as if you never made the will in the first place. So a will basically is a written declaration. So that's the first requirement. It must be in writing. A written declaration of a person's intention of how his assets should be divided and his instructions upon his death. And I added that last part, the instructions upon his death, because if you have nothing to give away, you can still make a will. If it is that you want to say that, listen, when I die, I want to be buried at X place in the Anglican Church Hall yard, you can put that in your will as your final instructions to whoever is going to bury you. So that is why I added that last part. Now, whenever we're making a will, there are a few things that we always make sure that we have. The first thing is that you have to appoint an executor. Now, the executor is just the person who, one, is going to take the will to court to satisfy the court that the will is valid. And two, after the court is satisfied that the will is valid, that executor is the person who is going to make sure that all your land is transferred to where it's supposed to go. Make sure that your instructions in relation to your money are carried out. Make sure that if you have children, whatever instructions you left for those children will also be honored. Where the will creates a trust, which sometimes is a bit more complex, usually, or not usually, but a lot of times we do trusts where you want to leave money to somebody for them to get it over time. So for example, you have a 2-year-old, you want to create a trust where the money stays in an account and he gets it either every year or on his 18th birthday, or you want to create a trust to leave money for the Baptist church so that, your offering keep going every Sunday. Whatever it is, you would appoint a trustee, and those people, there's an act which governs how the trustees are supposed to act. Where you have children, your will can appoint guardians for those children. And that guardian will be responsible for any money you left to the child. They will be responsible for whatever it is that you set out in your will for that guardian to do. Another thing about wills is that you can make a new will every day if you feel like. If you wake up today and you bought a new stove, you can make a new will to include that stove. And if you go to court tomorrow and you take out a fridge, you can make a new will to include that fridge. However, for every new will you make, you have to state that this new will revokes the old will, so that you don't have 2 or 3 or 4 different wills competing with each other at the same time. And then the last point, as I had said before, you can give directions as to where you want to be buried or how you want to be buried, whether you want to be cremated, whether you want your body to be donated, whatever it is, whichever direction you feel like giving, you can also include that in your will. And it's usually included at the top so that, you know, that's the first thing that is considered. Now, whenever you're creating a will, first thing is you have to be over 18, well, 18 years old and older. You can't be a minor and create a valid will. The second thing, the second thing is that it must comply with the Wills Act. And Section 6 just requires that it's in writing, that the will must be signed. And by signing means that you either sign your name yourself or you write your initials, or if you can't write, you put some mark that you intend to be a signature. Or for people who, let's say you just can't write at all, whether because your arms are sick or you have none, then you can ask somebody else to sign your signature on your behalf. The will must also be signed by 2 witnesses. Those 2 witnesses have to sign the will in your presence and in the presence of each other. So you can't sign your will at home and then you go to Rev's house and say, Rev, witness this for me, please. And Rev sign. And then you go up to Metron Hines and you say, Nurse signs, witness this for me, please. And she signs. That will is going to be invalid. All 3 of you must be in the same room at the same time. And all 3 of you must see each other sign all the signatures. The next thing is that you must have the intention to create the will. So if it is that you're just writing down wishes, but you don't really want them to take effect when you die, then you don't have the intention to create a will. And as such, your will be invalid. If you don't have the intention to give away the things that you put in your will, then you also will have an invalid will at the end of the day. If you're mentally unable to create a will, meaning, let's say you suffer from some illness, autism, or something like that, then the court may say that, you know, your will is invalid because you don't have the mental capacity. You not sure what it is that you're doing, or you don't understand the implications, then the court will rule that your will is invalid. The final thing also is that if it is that somebody forcing you to make a will and you write it and you sign and you give the land to your cousin because he did have a knife at your throat, then that will also be invalid. Whether, I'm not sure how the court will find out, but if it comes up, let's say you have a daughter who say no, it's threaten them, and she write that, I don't believe she would give it to that cousin because she don't like that cousin, then the court will do the investigation, and if they find out that it really was by force, then your will be invalidated. Also, if it is that you go to a lawyer to draft your will for you and they don't allow you to read over the will, you don't know what they put in it, you tell them that my land must go to Rev, but they write that it must go to Sister Robbie and they never allow you to read it, you just sign, then that will also be invalid. Let's say you prepared your will and everything is good, you sign it, you put it up in a drawer, keep it safe, but 5 years down the line, you decide that you change your mind and you no longer want to go forward with that will. First thing you can do, you can do another will that revokes the one you no longer want. You can just write a note, have it signed and witnessed in the same way that you do a will, to state that you no longer want the will you had done before. You can destroy the will completely, meaning you would have to burn it completely. You can't leave anything, any trace of the will. You can't tear it up unless you're putting it through a shredder where you're sure that it will be destroyed completely. Those are the three ways that you can take steps to, revoke your own will. The fourth mode of revocation is marriage. Now, if you make a will today and you get married tomorrow, then your will is automatically revoked. It basically doesn't exist because there are laws that govern how assets should be split between couples or between people who were married and are now not married, either because of divorce or death. However, if you do get married and you want to make a will, you can go ahead and do that, because then the court will say that, okay, he knew he was married, but he still wanted to deal with his property in this way. So for everybody who has a will right now and is single, whenever you get married, please remember that you have to redo that will. Even if you're writing the same things in it, you still have to execute a new will that's dated after the day you're married. Now, usually when I have clients who come for me to prepare a will, I have to tell them that, probate and administration costs are expensive, especially if you have a lot of assets. One way to avoid that expense is if you're sure of who you intend to give your property to, who you intend to give your money to. If you're a parent and you only have one child and you know that child going to get everything when you die anyways, what you should do is put their name on the title with yours. Or if it's bank accounts that you have, you want to add them to your bank account. That way, if you die, they still have access to these things. Or if you die, their name was already on the title, so they don't have a problem becoming the owner. That way, you won't have to go to court to probate or administer your estate. You won't have to be paying any debt duties at all. They won't have any trouble of having to go to a lawyer in the first place. So if you're sure you want to give your property to somebody, add the name to the will during your lifetime, to the title during your lifetime. That way, maybe you won't even need a will. But in the event you're unsure, then it's always best to make a will. That way, the government don't decide who gets what you leave behind. If you're going to make a will and you're going to visit your attorney, these are some of the things that they'll need to see in order to draft the will. They'll need to see all the titles for the properties that you own. They'll need your banking information. And by banking information, I just mean where you have the account. So if you have an account at Scotiabank, they want to know that it's my savings account at Scotiabank with account number 103. And that is it. You don't need to give them your PIN. You don't need to give them any of your personal information. They just need to know the type of account, the bank, and the account number. If you have shares, they're going to need to know the company you have the shares in and who you want it to go to. There's a mortgage on the property, you want them to know that, hey, listen, there's a mortgage on the property, because they'll have to pay out that mortgage before they do anything else. If you were married, they'll need a marriage certificate. If you got divorced, they'll need a divorce certificate. All those documents. You'll also need to know who your witnesses are going to be, so that they'll know who is going to sign the documents, and And you also want to know who your executor is going to be, so they can, because they have to add that to the will. The more specifics you have for these people and for yourself, is the better it is, because then there won't be any ambiguity in your will. They'll know exactly who is to get what middle names. So for example, Matron Hines is making a will and she's leaving anything to her nephew. She will say, my flower pots to Kemar Jonoy Sutherland. My nephew, I leave these flower pots. So you want to be as specific as possible. You can have the person's TRN, because you can't get mixed up with TRNs. You want to have the person's address. You want to have the person's occupation, just so your attorney can be as precise as possible when drafting your will, so your land don't go to somebody else by mistake. And then there's one exception that I have to mention in relation to things that you can dispose of. Two, actually. If it is that you have an insurance policy and that insurance policy has a named beneficiary in it, meaning you take out life insurance, and on the insurance documents, when you were writing them up, you said that when I die, the money must go to John Brown. You can't put that in your will, because when you die, that insurance policy is no longer yours and it automatically goes to John Brown. So it no longer falls under your estate. You can't will that. The second thing that you cannot will, or you have no control over gifting, is if you and another person own land as joint tenants, then you cannot give away that property if you die before the other joint tenant. So if Nurse Hines and I own property in Port Maria, and on the title, it's a we're joint tenants, then when I die, my portion of the land automatically goes to Nurse Hines, and I can't put it in my will to say I'm giving it to Sister Robbie. It, as a operational law, it automatically just goes to the other joint tenant. If it is that you are registered as tenants in common, meaning you own a percentage and they own a percentage, you can give away your percentage under your will. And I believe those are probably just the two exceptions for things that you cannot give away under your will. And lastly, if it is that you put something in your will, say for example, you have 4 plots of land and you put all 4 of them in your will, while you're alive, if you feel like selling all 4 of those plots of land, you can still sell it regardless of what's in your will. Because until the day you die, they're still yours. And so even though you put something in your will, you're still free to dispose of it. You're still free to do whatever it is you want to do with it while you're still alive. And so I think that would be a good start. That's a presentation. That's a good start. Should give you a good enough understanding of how you can acquire land or any item that somebody died leaving for you, or how you can protect yourself and your assets for when you die. And if you have any questions, then I'll ask Rev to just open the chat so I can answer a few questions. Okay,
thank you very much, Mr. Sutherland. I'm certain that we have been helped this afternoon. I want to believe that you have furnished some information for persons. Now, I'm going to ask you, if you have any questions on Zoom, you click the raise hand feature. On YouTube, you can type in the chat your question, and I'll read it for Mr. Sutherland, and you listen in. So we are now open for questions. as I said, if you are on Zoom and you have any, you can raise your hand. If you don't remember how to use the raise hand feature, just open the mic and I will recognize you. And if you're on YouTube with any questions, just type it in the chat and I will try and see if I can read them for you. All right, so everybody come. Any questions or comments? All right, yes. Go ahead, Sister Campbell, Daphne Campbell.
Thank you very much. Good evening. Question. I'm using a case. Let's say my parents would have owned lands and both of them died and they had children. I am the only child in Jamaica. My siblings are abroad. And I decided to sell some of the land. It's a good portion, and I would have sold about 5 lots from the land. But discover after the land was sold that my parents had no title for the land. And I am now having problem ascertaining titles for the land. What do I do?
Okay, so just so I'm clear, your parents owned the land, meaning they would have bought the land from somebody else and it's confirmed that they own the land.
It's confirmed, and they seem to have, well, owned the land for many years. Everybody knows them to have been the owners of these lands. They would have been farming, they lived on the land, but there isn't any documentation. And I do not know who the lands were bought from.
Okay, so let's start with the easier option. Let's say they did actually legally own the land. There's no title for the land, meaning the land is unregistered. You would have sold parcels of land. The persons who bought the land, who are the new owners, would have to go to the land agency. They'd have to do a survey of the land, the portion that they own, and they would have to do what we call an application for first registration. In that process, they'll have to prove that we bought the land, we own the land. However, there's no title, and all we're asking for is that you give us a new title for this piece of land. So that's the application for first registration, and that would have to be done by the people who bought the land from you. If it is that your parents own the land and there was a title, the land was sold without using the title, then that becomes a bigger problem than just getting a new title, because you would have bypassed getting subdivision approval from the parish council. You would have bypassed paying the taxes for subdividing. You would have bypassed going to NLA and splintering titles. You would have sold land that you don't own. So that now becomes a criminal matter if it is that the land was registered and it was sold without the title or without the title owner's permission. But for argument's sake, it's unregistered land. You still don't own the land, so you would have also sold without the owner's permission or without going through the proper channels. That also becomes a problem. So in that case, I would actually speak to a lawyer, because that's selling land without going through the proper channels is considered fraud, whether it's intentional or unintentional. and that would take, you know, time to reverse. It would take going through a very specific process to cure the fraud. Typically, nothing will happen to the purchasers if they didn't know about it. And if it is that, well, you didn't know about it either, chances are nothing major would happen to you, especially if it is that your parents owned it. You usually would just be asked to pay the taxes and actually go through the correct procedure. But yeah, the best advice I have for that is to seek an attorney, any attorney.
Okay, thank you very much. That answers Mrs. Campbell?
Thank you.
Okay, all right. Anybody else? As we are waiting, Mr. Sutherland, and the same issue, just a follow-up. What advice would you give to persons who go ahead and purchase land in a scenario just painted, not seeing a title?
Well, all right. In about 2 minutes, I'm going
Yes.
to, go over the whole purchasing and selling land.
Okay.
So when you're selling land, one, you have to make sure that you're the owner, and your attorney is supposed to say that. Selling land and buying land is a whole process. It's not just seeing somebody on a piece of land and say, hey, you live here? Yes. You want to sell me? Yes. Okay, how much? Give me $2 million. And I give you $2 million and you say, here's a receipt, you own the land now. It's not like going to the supermarket at all. When you're buying land, it takes a process and it takes time. For the vendor, the person who owns the land and is selling, you are going to have to provide proof that you own the property, meaning you'll have to provide title, or if it's unregistered land, you'll have to provide the deed of conveyance, which gave you the right to sell the land. You will also more than likely be told that you need to pay up all the property taxes, you have to pay the water rate, any outstanding lights, and you will have to do a sale agreement. Now, the sale agreement will have terms that you agree to, and then it will have terms that have to be there by law. Once you sign that sale agreement as the vendor, this is on the vendor side, sign that sale agreement, the purchaser signs the sale agreement, it has to go to the tax office. Now, if you say you're selling for $2 million and you tell the tax office you're selling for $2 million, they are going to go and look at the land to see if it's worth $2 million. If it is, that's fine, you pay 2% of that $2 million in taxes. If they feel like it's worth $40 million, then you pay 2% of that $40 million in taxes. After you pay the taxes, they'll give you a certificate to say the tax is paid, and you and the purchaser will sign a transfer. That transfer will be submitted to the land agency, and they will register the purchaser as the new owner, and you get a new title. If you're the purchaser now, it is prudent that one, or it's important that one, you go to NLA yourself, or your attorney goes to NLA and get a copy of the title. You cannot trust the vendor to give you a copy of the title, because they can give you a copy of the title that was canceled. They could have given you a copy of the title that was stolen. They can give you an outdated copy of the title. Any one of those things. They can print their own title and give it to you. So you want to go and look at the piece of land that you're buying, find out the address and the property description, which is pretty easy. That's usually at the tax office. And you go to the land agency and you say, hey, look, I'm trying to buy this plot of land. I need a copy of the title so I can see who is the real owner. That will cost you $500. If there's somebody young in your house, or if you know how to use the computer, you can buy a copy of that title on the land agency's website, also for $500. Once you get that title, it will tell you who is the owner, when they became the owner, whether there are any mortgages on the title, whether there are any caveats on the title, meaning a caveat is basically a stop order to tell the registrar you can't do anything on this title because I have an interest in it and I don't think anybody else must do anything until I say so. So it tells you all those things about the land. The next thing you want to do is ensure that you get a sale agreement. Now that agreement will tell you how long you have to pay for the land, that the vendor must give you the land without anybody living on it, who must pay the taxes, who will pay all the water bills. It will tell you that you have time to, go and look at the land. If survey the land, if there are any problems, you can cancel the agreement. It will tell you how you get back your money if anything happens, when you get back your money, how much money you get back. All the terms of the sale will be in that agreement. And then you can either have a lawyer go over it. You should have a lawyer go over it. I am a lawyer, and if I'm buying a house, I will still hire another lawyer to handle my sale. I do sales every day for other people, hundreds of millions of dollars, millions of US dollars, and I still would hire another lawyer to do my sale. And so it's my advice that if you have a sale, you hire a lawyer.
Thank you very much.
Then
sorry.
Title's office and you pay your money, you get your property. But as the purchaser, always go and get the title. That's your first priority.
All right, thank you very much, Mr. Sutherland. And the next person. You mentioned when the person dies intestate, and I think the presentation probably would have captured maybe just a child. But what happened if there are children, siblings, and you outline the process. You outline the process has to go through with the administration and all of that type of a thing. But as we know, and one of the reasons we ask for this presentation, sometimes the problem is with the many siblings deciding among themselves who is the quote-unquote rightful owner. What's the procedure? How to sort that out? You gave the legal procedure, the administration and all of that kind of a thing. Any word of advice as to two brothers, two sisters fighting over the piece of land?
So your mother died and she never leave a will to say you get it or your brother get it or split it, right?
Yes.
So, the government decides how that is to be split. When a person dies without a will, as we said, they're considered to have died intestate.
Mm-hmm.
And a person who dies intestate, their assets are divided in accordance with the Intestates, Estates, and Property Charges Act. In that act, it says that if it is just two children who are going to inherit, the property is split equally. Now, when you're doing the administration, any one of those children can apply. They don't need permission from their brother or sister. You can just go ahead and make the application to be the administrator. Once the court gives you permission, then it is your due, you're legally obligated to distribute the property in the way that the court says it is to be distributed. So if it's two brothers and the property must be split equally, if both of you can agree to have the two names put on the title and both of you live there, then you can get an order from the court stating that the property is to be sold and the proceeds from the sale will be split equally between the two brothers. So whatever dispute there is, once you go to the court, once you have the standing to go to the court, then the court will make the order that best suits your situation. Can't agree, sell everything and split the money. That is usually what happens when those disagreements arise.
Okay, good. Thank you very much. I don't see any questions on YouTube. All I've seen comments say very informative presentation, and someone else say thank you for that information. So there are just some comments that we see on YouTube, sir. No question at the moment. It seems as if you have answered everybody's question. I'm not seeing any other question coming up.
Well, I mean, these things are private.
Yes.
In any event, if anybody wants to talk to me afterwards, outside of this public space, Rev has my number. My number is on the screen. Or Matron Hines has my number. You can call me at any time, morning or evening, and we can discuss whatever questions you have.
All right, good. And your email address is also on the screen.
But my email is there. But
yes, all right. So let me say thanks again, sir. I am, as you rightly said, there might be some questions, but as we know, persons would rather talk to you privately, and so you have just extend that courtesy to everyone who may need to make contact with you. We want to say thank you very much, Mr. Sutherland, for your presentation this evening. We, I think also in the chat on Zoom, someone said, well-timed and very informative. Thank you, Mr. Sutherland. So we want to say thanks to you, sir. And we hope that out of your presentation, that persons who are having challenges in dealing with the deadlift, and for persons who may be joining us from other countries and may not know what we mean in Jamaica by deadlift, by now you should have gotten an idea based upon what was said. Thank you very much, and we want to wish you all the best in your practice and in your career, and we trust that God will continue to be with you in all that you do. Let's bow our heads at this time for prayer. Oh, you have one thing to say? Yeah, go ahead.
Oh, I was just saying thank you for extending the invitation. That's the first thing. And two, I didn't know that we had people from overseas on the platform. So I will just quickly add that if you live overseas and you make your will, you can put your Jamaican assets in it too, and that will still be valid in Jamaica.
Yes.
That's
yes, sir. We have some people who, as we know, I don't know if they migrate permanently or for a while, but we do some people overseas from Jamaica. And we also do have some persons who subscribe who are not Jamaican, but they come on each week. Okay. So I don't know if they want to buy land in Jamaica, but you're saying if they have interest, they can get in touch with you.
Sure.
All right. Okay, then let's bow our heads for prayer. Father, we thank you again for the time that we have spent together. And as we would have taken time out, dear Lord God, to listen up about important issues that we must deal with in our own lives and the other persons in our lives who are affected by what decisions we make. We continue to pray that we will have harmonious relationships as neighbors and as families and as communities. And so we pray, Lord, as we continue to explore some of these issues, we ask that you will indeed guide us in making wise decisions. And so we want to thank you this evening for the presentation about dealing with our assets or the acquisition of such. And that, Lord God, that as we continue to grow from strength to strength, we will do so based upon your wisdom and your guidance. Bless us as we retire for the night. In your name we pray. Amen. All right, everyone, you can open your microphones and greet each other. Next week, we continue with another